Defense of Marriage Act is a major subject of controversy right now. One provision of the Defense of Marriage Act says that for the purposes of federal law, any federal law, whether it be tax law or bankruptcy or benefits, for the purposes of federal law, marriage means a union between a man and a woman. And the legal issue is whether the Defense of Marriage Act violates the Equal Protection Clause. Equal Protection Doctrine is designed to protect people from discrimination, especially when the discrimination is based on so-called immutable characteristics. So we worry about people who are discriminated against on the basis of race or gender because those are things that cannot change. And now, at least most people see that sexual orientation, being gay, is something that a person cannot change.
Under the Constitution, the President has an independent responsibility to take an oath and then to interpret the Constitution and figure out what the President thinks the Constitution means. When the President concludes that a statute is unconstitutional, the President might nonetheless defend it out of respect for Congress, but in many instances, really starting with Thomas Jefferson and his refusal to defend the Alien and Sedition Acts, presidents have been willing to stand up to Congress to say statutes are unconstitutional. As a result, they will not defend it.
So it seems kind of odd, right? If President Obama thinks DOMA is unconstitutional and won't defend it in court, yet the Defense of Marriage Act, he's still enforcing it. And it's still hurting people, preventing people from getting benefits, preventing people from filing joint tax returns. Why would the president do that?
Attorney General Holder, when announcing the president's decision not to defend the statute, said that nonetheless the administration would enforce it so that the courts can resolve the question of whether the statute is constitutional or unconstitutional, rather than leave the issue within the executive branch. And so the view of the administration, which is a view that other administrations have shared over time, is that there is no obligation to defend a statute that one finds unconstitutional. At the same time, there is a concern about the president taking on too much power, too much authority, by not enforcing the statute, not giving the courts an opportunity to rule whether the statute is or is not unconstitutional.
In terms of who Congress is, that's really representative by the Defense of Marriage Act litigation. So the leaders of the House of Representatives said, we think that the Defense of Marriage Act is constitutional and want to defend it. But a group of, I think, about 180 Democratic representatives have filed a brief in some of these cases saying, we think the Defense of Marriage Act is unconstitutional.
Right, and in effect, the Obama administration is saying the Congress that enacted the Defense of Marriage Act illegally discriminated against gay couples, at least married gay couples, and that they acted in essentially a pernicious, impermissible way and need to be slapped down for acting that way, which is really a reflection in part of how different our attitude is today towards same-sex marriage than it was, say, 25 years ago, around the time the Defense of Marriage Act was enacted.
At the time that the Defense of Marriage Act was enacted, no state actually allowed gay marriage. Hawaii had allowed gay marriage, and that's what caused this scare that if some states start allowing gay marriage, then other states that don't want to allow it will have to recognize it, and the federal government will have to recognize it.
And everyone thought that the inevitable next step was going to be the Hawaii Supreme Court creating a right to same-sex marriage. And the statute was enacted in the aftermath of that decision, right? But it was essentially exactly what you said, right? But Hawaii still doesn't have same-sex marriage.
Yeah, I know, that's the irony.